You have an introduction, is that correct?
Yes, Your Honor. May it please the court, I'm Douglas M. Campbell, Sr. I've been a member of the Hamilton County Bar since 1977. I've had the great privilege to argue before this court a couple of dozen times, but not since Judge Franks has left the bench. That's been a while. It is my great pleasure today to introduce my son, Douglas M. Campbell, Jr. He's a graduate of Pomona College in Claremont, California, and the University of Tennessee College of Law. Along with his two first cousins, he is the fifth generation of lawyers in the family that date back to former Chief Justice of the Tennessee Supreme Court, A.W. Chambliss. It's my great pleasure to introduce him today, and he will be handling the argument of the appellee.
Welcome. Good luck to you. Glad to have you. All right. Did you call the case? Yes. All right. We will hear from the appellant then.
Good afternoon, Your Honors.
Good afternoon.
Zach England here on behalf of the Chattanooga Hamilton County Bar. And I apologize, I should have asked permission ahead of time, but I do have a new attorney to introduce if the court will allow it.
That'd be fine. Go right ahead.
This is Radonna Gaddis. Ms. Gaddis was a longtime paralegal under me and has just graduated law school and passed the bar. She is set to be sworn in tomorrow in front of Judge Demetru in Hamilton County. I'm tempted to ask her to be sworn in now and let her handle the argument. But do thank you for the consideration and happy to have her on board.
Welcome. Good luck to you and glad to have you. And congratulations to both of you.
If I may, Your Honors, request 4 minutes in rebuttal, please.
All right, sir.
Thank you. May it please the court, we are here on a granting of summary judgment at the trial court level on behalf of the appellee, Robert Gerwig. The basis for the granting of the summary judgment was essentially twofold. First prong centered on a statement, alleged statement that was made by Zach Gerwig, who was the son of appellee Robert Gerwig, that was deemed to be inadmissible hearsay. It did not qualify under any exception. Secondly, the trial court ruled that there were no genuine issues of material fact present, and the summary judgment was granted. We would present that the trial court erred essentially in three ways on this matter. Number one, we believe that the statement that was ruled inadmissible hearsay should qualify under hearsay exception 803 1.2d, which would be a statement by a party opponent via the agency principle theory. Secondly, that statement should have come in under the excited utterance exception. And then thirdly, that even taking this statement completely out of the picture, there are substantial genuine issues of material fact, both in conflicts between the testimony and evidence provided by the appellants, in addition to testimony provided by the appellee, as well as two independent witnesses who provided their testimony as well. Despite these substantive issues of material fact, the factual direction of the case is relatively straightforward. It involves a bicycle wreck that happened in front of Robert Gerwig's home. The allegations by appellant Needham that a dog owned by the appellee interrupted and subsequently struck the bicycle, causing a fall. The appellee Gerwig, Robert Gerwig, as I refer to him, the father, was not home. Instead, his son was on the premises that day along with other guests. That son, along with the two guests, male and female, would come to the aid of Mr. Needham. He would be helped off the road into the yard. Subsequently, Mr. Needham's wife would arrive, pick him up, take him on for medical care, and he would essentially undergo surgical intervention. Where the evidentiary disputes occur is to whether a dog or dogs were present and caused the wreck, and specifically the allegation by Mr. Needham that Zach Gerwig, the son, had made a statement advising that the dog in the yard was his father's and had wasn't sure why it was out that day, that the dog was never out. Mr. Gerwig, the son, denies that statement, and thus here we are. So focusing on the statement itself.
Let me ask you, the statement about the dog was in the yard, what does that actually have to do with whether or not that was the dog that ran out into the roadway your client supposedly struck? How does that help you in regard to that issue?
The statement is a salient issue in that it would show ownership of the dog by the father, who was absent that day. It essentially cuts into our proof of showing the ownership and the causation of the wreck.
Still trying to understand the statement of the dog in the yard versus a statement that this was the dog that made contact with the plaintiff's bike. Those are two different things, as I see it.
I hear what you're saying, Your Honor, and so essentially there was a dispute, of whether there was even a dog to begin with on the premises. That's denied as far as that goes with the parties. But ultimately, as far as identification purposes, Mr. Needham was able to identify the dog to the extent of details, but is partly relying on the statement by the son, who we believe was acting as an agent of his father at the time in caring for the dog, thus identifying the dog, the proximate cause of the bicycle wreck.
Weren't there two dogs?
That is an allegation and essentially cuts to some of the genuine issues of fact in this matter. Mr. Gerwig, who again was not present that day, advised that there were two dogs in the home when he left. Those dogs were left inside. The son, Zach Gerwig, denies that there was another dog besides Stella, the bulldog. And there is several different variations of Lexi Hughes, who was one of the independent witnesses there, eyewitnesses, as to whether there were dogs or not. So there is an allegation that there were two dogs. There's also been a denial that there were two dogs. So essentially, if you're looking at the statement from the principal agency dynamic, we have testimony from Robert Gerwig that he fully expected his son to take care of the dog. There's been certain allegations that this is a elderly, overweight, a precious dog essentially, and clearly it was of value and importance to Mr. Gerwig and his wife. Again, neither were present that day. Mr. Gerwig said he had no reason to believe that his son would not take care of the dog. Had he known that Zach, his son, would not take care of the dog, he would have made other arrangements. He did not give instructions, said he didn't think he needed to. Additionally, Zach Gerwig, the son, acknowledged in his deposition that he had watched the dog before in the absence of his father and his stepmother. He acknowledged that, yes, it was his responsibility to care for the dog, and there was no explicit agreement. Tennessee law does not require that, but that was essentially the understanding. And so, of the four-prong test of that agency principle theory, that first prong is satisfied. 2, 3, and 4 sort of follow suit. He made the statement in the context of the scope of his agency. He was there that day. He will maintain he was there to work on a car, but essentially it was an unspoken understanding that he would take care of the dog as well. Essentially that, and ultimately the statement would go against his interest in that by making this statement, he's exposing his father to liability.
Is that the test, though?
I'm sorry? Is
that the test?
As far as
As the agent himself. He's the agent.
Correct.
Doesn't it have to be whose detriment does it have to be? The agency or the agent or the principal, assuming you're right?
Well, the test is going to reflect back to the intent of the principal, essentially. It's for his benefit that he has this agent. Now, the statement itself, as far as being against his interest, it sort of works twofold in that if he's truthful, he's showing that if this dog had in fact caused this collision, it was under his watch and his care. He's risking not only exposing his father to liability, but also Mr. Gerwig was very emphatic in his deposition. I believe his words were, if his son wanted any part of his hide left over, he would take care of this dog. So I think we've got a threat of not only civil exposure, but also corporal punishment, for lack of a better term. So even disregarding the agency theory, there's still an argument that this statement comes in as an excited utterance. This was not a heinous car wreck with a fatality, but as Mr. Needham testifies, in under a minute, these individuals come to his aid. We have discussion about Mr. Needham and the son comparing clavicle scars due to a surgery that the son, Zach Gerwig, had just experienced. There's a suggestion that Mr. Needham was given a cigarette, presumed to calm him down. Lexi Hughes, in her testimony, talks about how Mr. Needham was rude, the situation was tense, there were apologies made, et cetera. And this was all happened, again, in a matter of seconds, leading up to minutes. This testimony is that Mr. Needham's wife picked him up somewhere between 20 and 40 minutes. And so, the policy behind the excited utterance is to, not prevent for fabrication down the road. This is more of a spontaneity. It was a startling event. Mr. Gerwig and guests testified that they didn't actually see the wreck, but they heard it, heard a thud. And essentially, Mr. Needham testifies that he'll eventually have to have surgery due to the severity of the injury. Now, again, taking this statement out, this is a factual blizzard of circumstances as to what actually occurred on that day. We have wildly conflicting testimony between the father, the son, but more importantly, Lexi Hughes, who I believe she testified as some sort of distant family member of the Gerwigs. But as you can see in the briefs, Ms. Hughes is contacted and immediately emphatically says the dogs were in the yard the whole time that day. She's emphatic that it was not the dog's fault. Points, I guess, what you could say comparative fault against Mr. Needham, but that directly conflicts any testimony from Robert Gerwig, the father, or Zach Gerwig, the son. Robert Gerwig acknowledges he was not there that day. He's totally relying on his son. He acknowledges no surveillance. Anything he's hearing is secondhand to his son. And ultimately, they're both emphatic, father and son, that the dogs were not out that day at any point. They were confined inside. They reference the dogs used the bathroom, or at least one dog used the bathroom inside, but are emphatic no dogs were in the yard, thus no way they could have caused the wreck. Ms. Hughes, directly out of the gate, makes this statement. She acknowledges the conversation under oath. When she's asked in her deposition, was there a dog there or not, all of a sudden she doesn't remember. And that alone should send this case back down. You've totally provided a genuine issue of material fact over the cause of this wreck. Was there a dog? Was there not? Clearly, we agree there was a wreck.
So she's said two different things, is what I understand you're telling me.
That is correct, Your Honor. She initially, when contacted, was emphatic that there were dogs in the yard. She then walks that back under oath. Essentially, here we are.
What about the cancellation rule?
Well, I don't believe that she ever actually canceled herself out. She never provided testimony that would, cancel out the previous testimony. She then essentially became ambivalent when she was testifying under oath.
Well, what is it that you say she said before and after? So I can make sure I understand exactly what you said.
Absolutely. Immediately upon being contacted, right out of the gate, she says the dogs were in the yard the whole time. Okay. Now she
says this.
She says this via Facebook Messenger.
Okay.
And I'm showing my social media ignorance here. That conversation was presented to her. She acknowledged it. She had a chance to address it, change it, dispute it, etc. She essentially could not explain why she said it. She sort of suggested confusion and sort of talked in circles, but ultimately confirmed that was her. She did say it, and at the time that it was correct.
And then she subsequently under oath said what?
She said there might have been a dog out. There may not have been a dog out. She essentially could not say.
Let me ask you, follow up really to my earlier question. What is the proof in the record that the defendant's dog, and he owned one dog, Stella. What is the proof that Stella was the dog that made contact with your client's bike in the roadway? I still haven't heard any proof to that effect. And obviously that's an element. You got to prove it was the defendant's dog, Stella. Where is that? Where do I find that in the record?
Well, Mr. Needham testifies consistently that a dog matching the description of Stella struck his bicycle.
I didn't see anything in your statement of undisputed facts that says that the dog, quote, matches the description of Stella. Because Stella, as I understand it, is a huge dog, and your client said it was a medium-sized dog.
I think
I didn't see that matching the description of Stella.
I think the description, I'm not sure I respectfully disagree with the characterization that Stella was a huge dog. Mr. Needham did describe the dog as medium build, short haired, with a brown spot, white. That matched the description as Mr. Gerwig testified and the others. Now, that's one angle of the proof, essentially. Clearly, that allegation is bolstered by Zach Gerwig making the statement as an agent of his father that this was my father's dog. We're at the summary judgment stage, Your Honor, and so the burden is lower. This should get to a fact finder to flesh out these inconsistencies and the credibility of the witnesses. Mr. Needham's wife also testified under oath that she saw the dog when she arrived. It was behind the fence at this point. But again, that contradicts the father and son testimony of this dog never left the house for apparently 15 to 16 hours, depending on whose timeline you believe.
Okay. Thank you.
Thank you.
May it please the court, my name is Doug Campbell Jr., and I'm here on behalf of the appellee defendant, Robert Gerwig II. I have a brief argument for your honors, but at this point in time, if you have questions following the appellant's argument that I could answer out the gate, I'm happy to do that now, or I can proceed with my case.
Pretty comfortable. You'll get some questions, so go right ahead.
Okay. As Mr. England noted, this is a fairly simple case. The plaintiff was injured in a bike wreck on April 16th in front of the defendant's home. He claims that a dog ran out, contacted his front tire, flipped and fell. We filed for summary judgment after party depositions had been taken because there was no proof in the record that the dog that caused this accident belonged to the defendant. There was no proof that a dog was even there, and that as a threshold matter, ownership of the dog that caused the accident would need to be proven by admissible evidence in order for this case to proceed past summary judgment. After taking a couple more depositions, we renewed this motion for summary judgment, at which point in time the trial court instructed us to specifically brief whether or not the alleged statement by Zach Gerwig fell under one of the exceptions to hearsay, specifically 803 1.2d, the statement by a party opponent agent. We believe that there is in no way, shape, or form an agency relationship between Zach Gerwig and his father. He was an adult, had his own job, never lived at that home. There was no communication between the two of them about his taking care of Stella. The entire purpose for him being at his father's house that day was to use his father's garage and tools to rebuild his car. There was no kind of quid pro quo. There was no discussion of instructions relative to his dogs or to caring for them. There's just no agency relationship between the two. And that even if you were to have described some sort of agency relationship, under the rule, the statement would have to be against the declarant's interests when it was made, not against the principal interests, against the declarant's interests. And there's no proof at all that this alleged statement was against Zach Gerwig's interests. You'd say, yeah, it was against his father's interests, but it was not against his own. And I believe I've cited two good cases, McCrae versus the city of Memphis and Daly versus Bateman, both that are on point on this. One in which a police officer's statement to someone about the location of a stop sign being down after an accident was held to not be against the declarant's interest. It was against the city's interest, but it wasn't against the police officer's personal interest when he made it. Daly, on the other hand, looks at a statement made during a disciplinary hearing, in which case it obviously would be against his interest to have made such a statement. Here, there's no interest of Zach Gerwig's that is violated by making this alleged statement to William Needham. Similarly, I don't believe this falls under an excited utterance. In order for this to have been an excited utterance, there would need to be a startling event, and the declarant would need to be under the stress of that startling event. As I pointed out in my brief, all of the people who were working on the car heard a thud and a grunt. Mr. Needham was laying alone in the road. There was no dog anywhere around. He himself testifies that he never saw the dog again after it initially impacted his front tire, and only saw it for a brief moment before then. He'd never seen a dog at the defendant's home before. He's never seen this dog ever again. But after hearing this thud and a groan, there was no blood, there was no screaming, there was no moaning. They walked down, helped him up out of the road, set him down under a tree, got him some water, offered him a cigarette. He was not under stress of some exciting event whenever he spoke with Mr. Needham. All of his actions back up the fact that he was clear, level-headed, calm, and was not, as I believe the test is, suspending his normal rational thought process. All of his normal rational thought process was totally level. So this doesn't apply as a excited utterance either. Finally, to briefly address the idea that there are other genuine issues of material fact, we, as the trial court agreed, believe that the threshold matter here is that the dog that is alleged to have caused this wreck needs to be proven to have belonged to the defendant. Without that, it doesn't matter if there's conflicting testimony on when the parties arrived to start working on this car, what time Mr. Gerwig got home that night, and if he spoke with other people then, or if he spoke with his son on the phone after. All of the other factual disputes in this come behind. They have to be able to prove that the dog that caused this accident belonged to the defendant. And outside of that, it doesn't matter, that they're immaterial from the standard of what exactly is a material fact. That a material fact must be one that has to be resolved. A disputed fact is material if it must be decided in order to resolve the extent of the claim or defense at which the motion is directed. And again, our motion was directed at the fact that ownership of the dog had to be proven by admissible evidence, and there is none. And with regard to his statements about Lexi Hughes' conflicting testimony, Lexi Hughes' statement that he reads out and puts in his brief is a direct quote from her hearsay Facebook conversation testimony, that she says specifically when asked by counsel if she would be comfortable testifying that she saw a dog somewhere in the yard that day. She says no, that there's not an equivocation, there's not a yes, no, maybe. She says no to that question. Further, gets back to, you have to be able to prove that, one, a dog caused this wreck, which there's really no other witness to. He's the only one who's ever testified that he saw a dog anywhere around this accident when it happened. No other witnesses. The other witnesses are working on a car with their backs turned. Nobody ever sees a dog. He never sees a dog ever again after the accident happens. Says he never sees it get led out of the road, never sees it leave the road, never sees it put in the backyard. At which point in time, I would like to say the cancellation rule that Your Honor brought up would apply. If he's providing a statement saying, I saw them, lead the dog into the backyard, and then under oath testifies that he never sees the dog again after it contacted his front wheel, those would cancel one another out, and we would be left with the testimony from the other people present who said that there was no dog outside, that Stella, the defendant's dog, was inside the house at all times. And we're left with the same position of you need to be able to prove the ownership of this dog. And he has not been able to do that, and without proof of ownership, there's no case here. There's some discussion that because it might have exposed his father to liability, that Zach's interests might have been impugned such that he's making a declarant statement against his interest, and it's referenced in terms of potentially him inheriting things. At the time, there was no lawsuit. There was no thought that there would be a lawsuit. If you go back and you look at the testimony from Robert Gerwig, he doesn't remember when exactly he heard about this, but it wasn't until after he received a notice of a law firm that he thought any lawsuit might have been filed. So expecting his son to have suddenly jumped to that conclusion ahead of time is preposterous.
How far can you go in looking at that analysis?
Well, I think that it would go back to whether or not the event itself was sufficiently violent enough for him to have expected there to be a wreck. Again, if he doesn't see any dog in the road after the bike falls, why would he think to tell his dad really anything about it? I can't imagine a situation in which if something sufficiently violent and potentially lawsuit leading to happened, that I would convey that. And I think that it undercuts the argument that this was some really violent injury, and instead was a man falling on a bike and breaking the most easily broken bone in the human body. Unless there are other questions, I'm going to wrap up by saying again, the threshold matter in this is that summary judgment was appropriate because without being able to prove ownership of the dog, which there is no proof in evidence, no admissible proof in evidence, summary judgment was appropriate.
Thank you.
Briefly on rebuttal, Your Honors, the argument that there was no instruction or direction from Father Gerwig to son Zach Gerwig may be true from an explicit standpoint, but there was certainly an expectation of duty, and that is laid out both in Robert Gerwig's deposition as well as Zach Gerwig's deposition as far as what the expectation was, the value, and the just the preciousness, for lack of a better term, of the dog, and again, the gravity of what may happen to Zach had this dog been neglected. Outside of just, again...
Can that amount to an agency, though?
Well, I think given the fact that this was a recurring understanding, granted, yes, it's an adult son who did not live with his father, but again, it testified that he was aware that it was his responsibility for Stella when his parents were away, and also the expectation from the father that he was to take care of that. And the assumption, the expectation, however you want to phrase it, that is an ongoing, it may be a fluid understanding, but again, it wouldn't be necessarily reasonable for a father to draft out a contract or some understanding for his son to take care of the dog, given again how much value and importance this dog had. It would seem to be that there's been a very common understanding of what's expected to take care of this dog.
Was there proof that he even knew his son was even going to be there that day?
He testified that he was aware the son was coming over to work on the car, but also, and said that he would have made other arrangements for the dog had he been aware that his son did not let the dog out or address the dog. Part of the issue has been this dog apparently soiled the home, and that was not welcome news to the father or the stepmother. And Zach, the son, acknowledged as well in his deposition that had occurred, and this was not met with with favor.
I thought the father testified that he did not have an expectation that he was going to be gone all day, that he didn't expect to be gone very long. I think he was going to the VA or going to some medical treatment, but he didn't have any expectation that he was going to be gone as long as he was gone.
That's correct. I don't believe he thought, he testified that he got caught in traffic coming home from Nashville, which is a very common occurrence coming through Chattanooga. But my understanding was the delay was for essentially an hour or two, not some 12-hour escapade. And as you see the testimony of the father, he arrived to an empty home. The house was soiled by the dog. The son testifies that he gets there much later in the day. He's home when the father arrives, and they sit around and talk and watch TV, et cetera, and go from there. There's also, again, conflicting timeline testimony from Lexi Hughes, the witness. Again, Robert Gerwig, the father, is adamant that his dog was never out that day. He makes references to stray dogs in his answers to interrogatories. He's questioned about stray dogs in his deposition. He can't articulate what he means by that. Zach Gerwig, the son, acknowledges there was never a dog anywhere, at any point, at any time outside. No barks, no visualizations, no anything. Lexi Hughes is adamant when she's first contacted that there were dogs in the yard. That flies in the face of each other as to where the testimony conflicts and the genuine issues of material fact exist. Mr. Needham and his wife gave consistent testimony. The Gerwigs and Ms. Hughes, the eyewitness, are the ones who provide the conflicting testimony. Thus, the genuine issues exist. I see I'm about out of time. I would ask this court to remand this case back down to the trial court for further proceedings unless there's any other questions.
Yeah, let me ask you, in the appellee's statement of undisputed facts, at number 38, he says at the time of the incident, the defendant's large, old, purebred English bulldog was inside the house and not involved in this incident. And then in your responses to the defendant's statement of undisputed facts, your responses stop at 34, and you never dispute 38. Why is that?
I don't believe there was any dispute as to the breed of the dog, and I would think large would be a subjective term. I don't know that would equate large with overweight. But
it's just not the breed and the size. It's also he was not involved in the accident. But you don't dispute any of that. I was curious about why. I mean, because that's a critical point, that you wouldn't have disputed that.
Well, I think the issue was disputed from Mr. Needham's response in his interrogatory and the allegations put forth.
Okay.
I believe Mr. Needham provides, I think it's page 132 of the record, his description of the dog. And again, after his fall, he's being helped up out of the street outside of traffic. The wife does testify upon her arrival. She views the dog. So there is continuous observation of the dogs via the Needham family.
Okay.
All right, thank you. Thank you, counsel. We appreciate your arguments, your briefs. We'll take this matter under advisement and attempt to get you